Let's talk about Title VII of the Civil Rights Act. Under Title VII, it is illegal for employers with 15 or more employees to discriminate on the basis that we just discussed in the last video. Discrimination under Title VII applies to every aspect of the employment process, from job ads to post-employment references, including hiring, firing, promoting, placement, wages, benefits, working conditions of anyone who is in one or more of the protected categories under the statute. The Equal Employment Opportunity Commission, or the EEOC, is the federal administrative agency responsible for monitoring compliance and enforcement with Title VII. Before a person claiming discrimination can bring a lawsuit, they must file a claim with the EEOC first. And generally, they must do that within 180 days of the alleged discrimination. The EEOC will investigate the claim. It also attempts to mediate the dispute to see if the matter can be resolved. If the EEOC determines that discrimination occurred, it will file a lawsuit on behalf of the person. If the EEOC decides not to bring the lawsuit or hasn't made a decision within 6 months, the person can then proceed on their own in court within 90 days of receiving a quote-unquote a right to sue letter from the EEOC. There are 4 types of wrongful activities under the statute: disparate treatment or intentional, disparate impact, we call that unintentional, hostile environment, and retaliation. Let's talk about each one of these. Intentional discrimination or disparate treatment. A plaintiff who sues on the basis of intentional discrimination must show that they were treated less favorably than others because of their sex, race, color, religion, or national origin. The elements that one has to prove is they belong to a protected class, they suffered an adverse employment action, being fired, and 3, the action occurred under conditions giving rise to an inference of discrimination. The book example focuses on the hiring. So if a plaintiff who wants to claim they were discriminated against because they didn't get a job, the plaintiff who sues on the basis of intentional discrimination in hiring, they must show the following. They were members of a protected class, they applied and were qualified for the job in question, they were rejected by the employer, and the employer continued to seek applicants for the position or filled the position with a person not in a protected class. As you can see, as we move forward, these things are a little hard to prove, but we'll go through some cases. I want to use a real-life case as we look at the first 3 elements that I introduced. They belong to a protected class, they suffered an adverse employment action, and the action occurred under conditions giving rise to an inference of discrimination. The Guzman versus News Corp case was a pretty big discrimination case. It's an example of somebody who was terminated. The facts: in 2009, Sandra Guzman was an associate editor at the New York Post. She filed a lawsuit against the newspaper and its parent company, News Corp, alleging unlawful employment discrimination based on race. The Post published a controversial cartoon which depicted chimpanzees shot by 2 police officers. This cartoon was criticized for its racist undertones as it appeared to reference President Barack Obama in a derogatory manner. Guzman contended that the cartoon exemplified the pervasive racism within the workplace at the Post. She claimed that her termination from the Post was a retaliatory act resulting from her internal complaints about the cartoon itself, but also the discriminatory environment of the news organization. So step 1, plaintiff has to show, not prove. They don't have to prove at step 1. They have to show facts that meet the elements, the 3 that we talked about. I'll introduce them again in a second. We call this the prima facie case, a case that appears to be true when we first look at it. So the plaintiff is creating a presumption that discrimination has occurred. Guzman is Black, Hispanic, Puerto Rican female who worked at the Post as an associate editor from July 2003 to September 29, 2009. She was terminated from this position. While employed, she received benefits, followed the rules and policies, served on committees, and was successful in running her section of the newspaper. She was responsible for editorial content and the production of special sections of the paper. Our first two elements, that she's a member of a protected class and that she suffered an adverse employment action. Number 3, the action occurred under conditions giving rise to an inference of discrimination, showing that an employer treated the plaintiff less favorably than a similarly situated employee outside his or her protected group. Her arguments were that she was treated differently than a female white editor who was not discharged when her once profitable section of the newspaper decreased. Instead, the white editor was transferred to a different position. In contrast, she was terminated when her section of the newspaper was reduced. Also, she claims that there was racist remarks that were directed at her. She complained about the cartoon, and the environment was a hostile place to work. Some examples straight from the case itself. She provided evidence of a sexually charged environment at the Post during meetings and during holiday parties, that some of the male co-workers, especially in the management positions, leered at her in a suggestive manner, commented on her appearance, made frequent suggestions of inappropriate sexual favors. At one point, a management male individual showed her and other female co-workers a picture of a naked man, discussed the sexual exploits of colleagues, reported visits and entertained visitors at strip clubs, and other offensive types of remarks. So step 1, on its face, it looks like a case that is discriminatory. So step 2, the burden now shifts to the employer defendant. They have to present evidence that its decision was based on legitimate, non-discriminatory reasons. If they can't do this at this point, then the plaintiff will win. The newspaper argued that she was terminated from her position because her position was eliminated. It was not making a profit anymore, and they eliminated the section of the newspaper and therefore eliminated her position, and that there was no suitable position available for her. So now the burden has to shift back to the plaintiff. To win, the plaintiff has to show that the employer intentionally discriminated. So the burden shifts back to the plaintiff to prove her case, either by showing A, the reasons the employer offered were simply a pretext, i.e. not the true reason, or that a discriminatory intent is more likely than not. So now we're at the point where we're shifting back, and her evidence that she shows at this point is, while the defendant stated the reason for terminating her employment, she's saying it's pretextual. First, the defendant argued that her position was eliminated because Tempo, the section of the paper, failed and was closed. But Gussman points out that the decision to close Tempo completely was not made until after she was fired, although the decision to reduce the size and frequency of Tempo was made prior to her discharge. In addition, defendants rely on the data suggesting that Tempo failed financially, but Gussman counters with evidence of Tempo's positive performance as compared with the New York Post as a whole. And measured in terms of operating income, it was doing well. Plaintiff's evidence creates the dispute, the court says. So this is going to go to, it was scheduled to go to a full hearing. And I do want to know one more point that she raised, that the court pointed out in the case, that the record reflected that she could have been transferred to an open editor position as an alternative to terminating her. But the defendant said that they fired her instead than offering her that position because they believed she would be dissatisfied with the pay decrease. But that's not really up to them to make, right? And she testified that she would have accepted the position at a lower pay. So ultimately, the court said that this case, there was enough evidence for this case to move forward. It never went to a full-out hearing in the case because the employer settled with her. But this is how a case would work. The plaintiff has to bring forth some evidence to show that discrimination has occurred. The burden shifts to the defendant to give a non-discriminatory legitimate reason. And if they do, then it shifts back to the plaintiff to actually prove discrimination. So let's talk about unintentional discrimination or disparate impact. Disparate impact discrimination occurs when a protected class is adversely affected by an employer's practices or procedures, even though they do not appear to be discriminatory. For example, applicants are given tests as part of the hiring process. The results are used to select applicants for job openings. These tests may have unintended discriminatory effects on a protected class. The Supreme Court has said is that tests used for hiring must measure the person for the job and not the person in the abstract. Disparate impact applies if the employer has a neutral rule that on its face is not discriminatory, but in practice excludes too many people in a protected category or class. For example, there have been a lot of employers with these test cases that concluded that they were discriminatory. Let's go through some cases. In the Dothard case, this is out of Alabama, but it went all the way up to the United States Supreme Court. Alabama had a minimum height and weight requirement for prison guards, which disproportionately excluded women. The court ruled that these physical requirements had a disparate impact on female applicants and were not necessary to perform the job. So employers must prove that physical requirements are essential to job performance and not arbitrarily restrictive. This was a discriminatory action. Dial Corp required job applicants to pass a strength test for factory jobs. The test disproportionately eliminated female applicants. Again, court found the test was not a good predictor of job performance and unfairly excluded women. So employers cannot impose physical tests that are not truly necessary for job performance if they are disproportionately excluding certain groups. Abercrombie and Fitch had found themselves in a discrimination case. They had a strict look policy that prohibited head coverings. A Muslim applicant was rejected for wearing a hijab even though she was highly qualified. The court ruled, this was a Supreme Court case, Supreme Court ruled that the company violated Title VII because even neutral dress codes cannot disproportionately impact religious groups unless there's a strong business reason. So workplace appearance policies must allow for religious accommodations if they are disproportionately affect employees of a certain faith. Criminal background checks is another area. The event planning company Freeman used criminal background checks in hiring, while the policy applied to all applicants. Black and Latino candidates were disproportionately disqualified due to a systemic disparities in the criminal justice system. The court initially dismissed the EEOC's claim, arguing that statistical evidence was flawed. However, similar cases have succeeded here, which ultimately led to companies modifying their background checks. So employers must ensure the background checks do not disproportionately exclude protected groups, and unless they can prove a business necessity for the disqualifications. But the key here is evidence. You can't just claim it. You actually have to prove the disparity. One more case, and this one's a little different. We call this the reverse disparate impact case. This all the way up to the United States Supreme Court, came out of Connecticut. The city of New Haven threw out the results of a firefighter promotion exam because African American firefighters scored lower than white firefighters. The city feared a disparate impact lawsuit. So the white firefighters brought the case. The Supreme Court ruled in favor of the white firefighters, stating that throwing out the test results solely to avoid disparate impact claims was illegal unless there was strong evidence the test was flawed. So employers cannot take discriminatory conscious actions to avoid disparate impact liability unless there is clear evidence of discrimination in the hiring process. The steps in a disparate impact case very much the same as our last one. The plaintiff must present the prima facie case, not prove it here, only show that there's a disparate impact, that the employment practice excludes a disproportionate number of people in a protected class, but important, need statistical data. You can't just claim it. There has to be some evidence. The examples, plaintiff is African American and the employer requires applicants to take a test, and a far higher percentage of whites than African Americans passed the test required for the job. If that would be statistical data, you could see who passed and who didn't. Number two, then, if we have that, we got burden shifting. The defendant must offer some evidence that the employment practice was a job-related business necessity. An example would have to show that the test predicted job performance. That would be valid. From there, and to win, we have the burden shifting again. The plaintiff must now prove that either the employer's reason is a pretext or that other less discriminatory rules would achieve the same result. One last case, Kaplan used credit checks to screen job applicants, arguing that financial responsibility was important. However, this practice disproportionately disqualified African American applicants because of racial disparities in credit scores, and the court dismissed the EEOC's case due to insufficient statistical evidence. But I will say similar lawsuits have forced companies to reconsider this idea of a blanket credit check policy, but nonetheless need the evidence. All right, hostile work environment. Employers violate Title VII if they permit a work environment that is so hostile toward people in a protected category that it affects their ability to work. This concept of hostile environment first arose in the context of sexual harassment. Sexual harassment involves unwelcome sexual advances, requests for sexual favors, and other verbal and physical conduct of a sexual nature that are so severe and pervasive that they interfere with employees' ability to work. We have two categories of sexual harassment: quid pro quo, Latin for one thing in return for another. This is harassment that occurs if any aspect of a job is made contingent upon sexual activity. And then the hostile work environment harassment occurs if sexual talk and activity are so pervasive that they interfere with one's ability to work. This was Sandra Guzman's one of her arguments. Examples of offensive jokes, intrusive comments about clothes or body parts, public displays of pornographic pictures. Those aren't the only examples, those are just some examples. The Supreme Court has ruled that same-sex harassment is also a violation. Hostile work environment applies to all protective categories. Court of Appeals, Circuit 11, I believe, has ruled that offensive language and crude gender-based remarks can create a hostile work environment, even if they are not personally targeted at the plaintiff. Here's an example, hostile work environment case. Castleberry, two African American workers allege that their supervisor used racial slurs, threatened their jobs, and treated them differently than white employees. They sued, arguing race discrimination. The court, this is a Third Circuit Court of Appeals case, ruled that even a single racial slur, and in this case they were using the N-word, could be enough to establish a hostile work environment if it is severe. So what's important? Even an isolated incident can constitute a hostile work environment if it's severe enough. Another aspect of hostile work environment is third-party harassment. In the Costco case, a female Costco employee was repeatedly harassed by a customer, and the company failed to take appropriate action to stop it. The plaintiff was Dawn Supo, worked as an employee at Costco in Illinois, one of the stores in Illinois. Over the course of more than a year, she was stalked and harassed by a male customer while working. The customer followed her around the store, made unwanted advances, stared at her, and repeatedly tried to engage her in conversation despite her objections. The harassment escalated when the customer touched her on the shoulders and wrists, making her feel unsafe. Supo reported the harassment multiple times to Costco managers and supervisors. They failed to take effective action. They did not ban the customer from the store, nor did they provide Supo with meaningful support. This situation caused significant emotional distress, leading her to eventually quit her job. And the court ruled, Seventh Circuit Court, ruled that employers can be liable for harassment by third parties such as customers if they fail to intervene. One last case in this category out of Washington, D.C. A lesbian employee at the D.C. Metro Police Department alleged that her supervisor made homophobic comments, mocked her sexual orientation, and created an abusive work environment. And the court ruled in her favor, emphasizing that harassment based on sexual orientation can create a hostile work environment under Title VII. Online harassment. Online activities of employees can lead to claims of a hostile work environment. Employees who engage in racial jokes, ethnic slurs, or other similar types of comments in social media posts, texts, emails, blogs, employers must be vigilant and take complaints serious. I know I discussed this about being terminated under the labor law section. Even if you're doing that in off-hours activities, it still could present an issue. You could be terminated if you're the one doing this conduct, and if it's targeted at an employee, the employer could be on the hook if they don't take action. Our last form of discrimination under Title VII, retaliation. Title VII also prohibits employers from retaliating against workers who oppose discrimination, bring a claim under the statute, or take part in an investigation or hearing. An employer can defeat a retaliation claim by showing that there were other non-discriminatory reasons for his action. So what is retaliation? Means that an employer has done something that would deter a reasonable worker from complaining about discrimination or punishing a worker for doing one of those things. For example, being terminated, demoted, poor performance reviews, changing terms of employment, conditions and benefits of that person's employment. Any one of these things can constitute retaliation. Remedies for one of these cases: if we have a successful plaintiff, what can a plaintiff get? The remedies are available to a successful plaintiff, including hiring, reinstatement, retroactive seniority, back pay, front pay, compensate for future wages, and reasonable attorney's fees. In intentional discrimination cases, you can see compensatory damages, any damages stemming from that discrimination. Punitive damages may also be available for intentional discrimination if it is shown and the employer acted with malice and indifference. To reduce employees' chances of winning substantial awards in these cases, many employers often require employees to arbitrate any future employment claims. Plaintiffs tend to win less in these types of cases than in any other types of case, and when they win the awards, they're really kind of less than when I say other types of cases, like negligence. Also, in these kinds of cases, when we see a win, they often lose at appeal as well. These are really tough. If you have an employment agreement, comb the agreement and look for an arbitration clause, because that's can create some issues in and of itself, as you learned in the hot coffee case. I'm going to end this section with there is a federal body of law. The Equal Pay Act of 1963 requires equal pay for male and female employees working at the same establishment doing similar work. Um, as you know, this is still an issue today and still a work in progress. Getting better, but still we don't see female workers getting paid equally as male workers.